So yeah, that's kind of my disposition on it. Like, I think be careful what you wish for. I don't think you want to testify for hours and hours and hours. I think, um, I think, I think 15 minutes is too short because I know a judge that does 15-minute scheduled hearings, and I think that's a little too short. I like the at least 45 minutes to an hour.
Welcome to the Evans Disability Podcast. We hope to be your definitive guide through the Social Security Administration landscape. I'm Peter Evans, your host and managing partner at Evans Disability, a law firm that handles disability cases throughout the United States. Before we dive into today's episode, I want to mention a special resource for our listeners. Click the link below to receive a free SSA Disability Guide from Evans Disability. This guide is packed with details on SSA disability programs, expert tips for winning your case, and sample questions from actual disability hearings. Join me as I sit down with special guests, including experienced lawyers, our extremely well-trained staff, and even a former Social Security law judge. If you find our content useful, please hit the like button and don't forget to subscribe to stay updated on our latest discussions. I hope you enjoyed today's episode.
Were you ever persuaded by a closing argument from a brilliant attorney that just tuck you from like, okay, I'm not going to pay this case to, I mean, obviously you don't have to say me, but if you want to, I won't.
Well, of
I'm
course,
kidding.
you were the first person who came to mind. Uh, I feel I I think a brief is very helpful. Now, myself, I think receiving a brief, it was never a requirement, but I think it's a roadmap.
Yeah.
I think yeah, and so similarly, and I think receiving those pre-hearing, it's very helpful. Okay, there were times there might be a unique issue, and I would ask for a brief post-hearing. As far as the argument goes, I think it's d a piece of the puzzle. It's something I'm hearing the perspective, I've done my review, maybe we have an opening brief, and it's a piece of a larger puzzle, I guess, and it helps me to, have someone summarize a position on a case.
That's awesome. That's good. That's good to know too, as someone who's kind of the managing partner of the law firm of opening briefs. I've had such unique experiences with different ALJs across not just across the country, but also like in a singular office, and I joke a little bit, but I've had one judge say, I ask everyone for an opening statement, but I only believe 50% of what they say, if that. And then, Mr. Evans, I believe about 60% of what you say, but take that as a compliment because that's the highest I'm giving anyone, in their opening statement. And so I laughed, and him and I were, kind of buddies. And then, and you get one ALJ who's like, told me, you can turn in a brief, I won't read it. And I'm like,
Mm.
okay. So it's like, and then I have another ALJ, she gets very upset if you don't turn in a brief pre-hearing. So it's across the board. Like everyone has their unique, and it's like in any field, right? Like whether you're a mechanic or a lawyer or a judge, human beings just show up as the human being they are, um, and so you get these unique experiences with different judges. Um, it's
Yeah.
not all robots. No one's a robot.
And, I have to say it was never a requirement for me. It was useful, useful piece of information as I'm reviewing that file and preparing for hearing myself. It's it was useful for me to read them, but it was never a requirement. It was just a nice and helpful thing to see, along with the many other pieces of paper I would see in that file. So, you're right. People are different. Everyone's different, and it's only through having experiences with them that we learn these things. And that's where we rely. You talk about camaraderie. That's where we rely on our, colleagues sometimes too, who have appeared before these judges that we may not have appeared before. to find out a little bit more so we can present that best case. So if they're one of these must-have opening brief folks, it's good to know that.
Yeah. No, for
Yeah.
sure. For sure. Um, one of the things, and again, I appreciate your time. One of the things that I'm curious about is that as a administrative law judge, you're specifically focused sort of on the hearings, the cases at a hearing. How, and obviously, I assume that every administrative law judge understands the process of application, reconsideration, hearing. That process now, on average, is taking 2.5 to 3 years. So by the time they're getting to you or to an administrative law judge for disability, they have probably waited 2.5 to 3 years being denied along the way. And then, and this is probably one of the top 5 complaints, for lack of a better word, that we get from clients that we represent. And then they're given, depending on the judge, 30 minutes to an hour to present their case as they've amassed 1,000 or 2,000 page file, or I've seen 5,000 pages worth of medical records too. But the average, I always say, is about 1,000 pages of file, and 500, 600, 700 pages of medical records. And I've waited 2.5 years or 3 years or 4 years, and I get 30 minutes. Do you have any thoughts on that, or
And whether it should be more than 30 minutes?
just more, or just kind of like we talked about before, like how much of that paper file do you think you and your colleagues have read before walking in? And I always say it like we talked earlier, it's the crescendo. The work is the medical records, and the judges read them and presenting it. And that's where they're going to decide it. But I just was curious about your thoughts on that, especially as you're coming in on the claimant side.
I always felt, I guess, just when I had the hearing, I felt that the case was heard. I would usually do a hearing. I would schedule them about 45 to 60 minutes apart when I would do my hearings. And I guess, hopefully I'm correct on this, but my takeaway from those hearings is that we covered it. We went through the steps. We talked about it. And it is an opportunity to be heard. And there were times in the hearings where I knew that was the case, where maybe I, through review, because again, this is we talk about the puzzle. It's a piece of the puzzle. This is an important part of that. But as you said, we've got those documents. Much of what I'm hearing during the proceeding is something I've already read, and I know some background. But this is it's part of the person's story, and it's an important part of the process to have this opportunity to be heard. And so I always felt that between my questioning, the representative's questioning, the claimant might freeform a little bit, and that was good. And I would welcome that, because I think that's necessary. And I would leave these hearings feeling that the case had been heard.
That's great. I agree.
Position on that.
What's my position? I always say, be careful what you wish for. I've done. I was a public defender, and then have done quite a few jury trials. People who are on the stand testifying under oath for a long time, it is exhausting. At best. And it really comes down to, testimony, and it kind of depends on the judge too. Like, you are a very, very kind, and listened and fair judge in my professional and personal experience. You're not coming in to crucify anyone as they testify. I have different experiences with different judges across the country, and clients do too, where it felt like I was just cross-examined for, as in a trial. This was not free form, and this was not like I've seen judges get angry because clients ramble too much, and then basically, for lack of a better term, being told to be quiet, and as their rep and as a claimant coming in, it can be difficult to testify in and of itself. That's why I like phone hearings too. It kind of takes away the body language if someone's frustrated, takes away you know, the the facial expressions, and it can, especially if you already are having or exhibiting some nervousness or anxiousness about the hearing itself, and we kind of know the judge and their disposition generally. And again, it's just people being people. We wish, on so many levels that every ALJ came in with just this open-mindedness and like, I want to be fair, but so much of it, like I said, and we're going to talk about a little bit this, here in a little bit, hopefully, is that how much do medical records matter? Right. And I have a pretty big opinion about how much those matter. But so yeah, that's kind of my disposition on it. Like, I think be careful what you wish for. I don't think you want to testify for hours and hours and hours. I think, um, I think, I think 15 minutes is too short because I know a judge that does 15-minute scheduled hearings. And I think that's a little too short. I like the at least 45 minutes to an hour, with some room to go over, and just in case not every case is the same. I think letting the client be heard is important, but also like this is where the reps come in and say, like, listen, this is the topics we're going to talk about. We don't need to talk about all of this over here, but we're going to focus in on this. And the judge probably has even less than that they want to talk about. So that's kind of where I stand on it.
And it's still, the clients are so nervous and just different factors influencing them when they go into the hearing. And so sometimes, and no matter how much you have prepared that client, they are going, they want to tell their story or maybe go in a different direction, or they're not listening closely to the questions. And I think that's usually because of nervousness. That's just been my experience. And sometimes you have to say, really, what I used to do in my hearings, I'd say, no, really listen in to the question that's being asked and do your best to answer. And the representative sometimes would have to do that too. And it's not that anything against the claimant, it's actually to facilitate the process. So because we do only have so much time. So we want to get to as much as we can in that limited amount of time, And so sometimes it's just reminding claimant is what from judge's perspective, client from representative's perspective, that we're just really listening into those questions.
Well, and then also too, there's so much pressure just, I think, from a national level, from a publicity level. Like, some of these hearing offices are extremely backed up already. And if you had one-day hearings for every single disability claimant pending at a hearing office, it just isn't practical. Claimants, instead of waiting a year, would be waiting 3 or 4 years for their hearing.
That's an excellent point.
So there's just not a practicality to doing a full day hearing for one case. I want to honor your time because I know that we talked about being an hour today, and I just wanted, we're kind of hitting that hour point, and I do have a few other questions, but I don't know if you have something you need to go to.
No, I have to say that I could talk. I love talking about Social Security. I still nerd out on it. Don't you feel that way? I just love talking about it. So yeah, let's keep going.
Okay. Well, if you have any appointments or time thing we need to kind of honor, just let me know, and we can.
Absolutely.
All right. So then my next question was just, often judges will say, if not 90% of the time, okay, I'll take your case on advisement. I'm not going to make my decision today. I'll make it later. And I don't know if you know this about me. I used to be a hearings reporter while I was studying for the bar exam. in the Portland, Oregon office back in 2000. And so I got to meet all the judges that were doing hearings at that time because I was a hearings reporter in there hitting record on the tape recorder.
I wish I could have done that as part of my training. Just to see different ways of doing hearings. Wasn't that an education? And
I
it was.
I sat in probably, I don't know, 5 hearings a day for a year, 6 months to a year. I can't remember exactly, but it was, I got to see not only all the different judges in Portland, but I got to see all the different lawyers come in and present their case. And then after the hearing, certain judges had a form they'd fill out. And in my experience, they had made their decision, but just weren't going to say it out loud at the hearing unless they won, unless the client won. And then that would be like 10% of the time. So but they would share like, yeah, I don't think I'm going to pay this case, and I know it's a written decision that comes in the mail, 60 to 90 days after the hearing, but that was my experience. I was just curious my experience is just my experience. So I'm curious about, if you want to even answer the question.
Well, I think as you mentioned, there are some cases where I just know in the hearing that it's favorable, especially, whether that's just it is favorable or let's talk about amending the onset date. Have you talked to your client about that? And we go from there. I I think that making a decision, you know, I was good at making a decision it in my work because that's part of what we do. Some people have a difficult time, and that's okay. That's okay. For me, it still required deliberation though, just to have the pause, because there's that that feeling immediately after the hearing, that you're like, I'm coming in unprepared. I've done my preps. Okay. We just had this opportunity for a client to be heard. We've had this representative, Mr. Evans, doing an amazing job and a closing argument that brought tears to my eyes. And then now it is time to take all of that and just pause and then make a decision. I think the pause is very important. Not that you should be pausing for 3 months to make
Right.
your decision because the claimant is waiting and they've been waiting a long time.
Right.
But a pause is okay. And so I think that was part of my process, especially in cases that were just, there's some unique cases that come across our desks, and it's important. And sometimes too, it's a job where we're working on our own, but we also have resources where we can say, turn to an attorney at our office and ask them to research a unique area of the law. And these attorneys were very dedicated to their work and good people. And so they were very helpful.
I was going to ask you, speaking of those attorneys, reading the files, doing 50 hearings or 45 hearings a month or however many. Did you get help with writing the actual decisions? I know judges have to sign their name to it, so I'm sure they read it all very thoroughly. Or was there a season in time too that you just wrote your own decisions?
Part of our process is to work